I have a number of videos discussing how long can police hold you while giving you a citation, and I will link those videos above. But in this video, I will discuss how long can police hold your property, particularly your cell phone, before giving it back. This case is from the 4th Circuit Court of Appeal, and it is United States versus Pratt. In this case, the FBI are investigating a prostitution ring. They see online that there's an advertisement for sexual services by a 17-year-old woman. So they set up a meeting spot. An undercover agent goes into the hotel room and interviews this woman. She says that her quote-unquote boyfriend is standing outside the hotel waiting for her. So more officers arrive and they come and interview Mr. Pratt, who's standing outside. He's holding his cell phone in his hand. So the officers ask him if he has any nude pictures of the girl on his phone, to which he answers that yes, he does have some pictures. The officers ask if they can look into the phone and look at those photos. Mr. Pratt refuses to provide consent to the search. He also refuses to give them the passcode to turn the phone on and unlock the screen. So the officers seize the phone and they tell Mr. Pratt that they will get a search warrant to look into the phone. Mr. Pratt is indicted on 9 counts, including sex trafficking of a minor, and possession of child pornography, which are those pictures that he had on his cell phone of the 17-year-old woman. Now, at the appellate level, Mr. Pratt says that the district court made a mistake when it didn't suppress the evidence derived from that phone, meaning they didn't throw it out of the trial. Now, he doesn't say that the seizure itself of the phone was unconstitutional. What he says is that the delay of getting the search warrant to look into the phone was unconstitutional. In this case, the FBI took 31 days before they actually got the search warrant and looked into the phone. The government makes 2 arguments. Number 1, they say that it was difficult for the FBI to get a search warrant because there were a lot of different agencies involved and it took time to figure out who had jurisdiction. Alternatively, the government says that they could have held the phone indefinitely because it was an instrument of a crime. For example, FBI can hold a gun in a murder trial while the case is pending without giving it back. So same idea applies here. They could have held this phone for as long as the case was pending. The appellate court in this case says they will conduct a balancing test, meaning they will balance the interest of the government in seizing that phone against the possessory interest of the individual of having that phone back. And in this case, they say that it should have never taken 31 days for the FBI to get a warrant. It is just too much time. It doesn't take that many resources to simply get a warrant. And the appellate court does not buy the argument that there's a lot of jurisdictions and they couldn't figure out where to get the warrant. In fact, it probably would have never even mattered where they got the warrant as long as they had one before they searched the phone. Moving on to the government's second argument that they could have held the phone indefinitely because it was an instrument of a crime, the appellate court does not agree here. They say that the phone itself is not evidence of anything. It is the files that are contained inside the phone that have any evidentiary value. So that means that the government could have taken the files out of the phone and later got a search warrant to look at those files, but they could have never held the phone because the phone itself is not like a gun that has incriminating value to it on its surface. Finally, the appellate court says that the delay of getting the search warrant and looking at that information was unconstitutional, meaning that all the evidence derived from that phone should have been suppressed at the district court level. And now looking back at the record, the appellate court says that it is insufficient evidence to convict Mr. Pratt of possessing any child pornography. We don't know what those images on the phone look like because we no longer have those images. So they remand the case back to the district court to figure out if there's sufficient evidence or if they want to retry Mr. Pratt for child pornography. The lesson in this case is don't consent to a search by the police and make them do their job, get the search warrant, and then get a good attorney who will argue that there is some mistake in getting that search warrant. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.